As an attorney, it's your job to support your own experts and to make sure that they say what you want them to say, that they can say what you want them to say. But it's also your job to try to limit the other side's experts. What are some of your go to approaches when you're wearing your bad expert hat? Which experts should be aware of?
One approach that I have found can be particularly effective, and I've mostly employed this with damages experts, although I'm sure you could do it in other ways too, is to accept the premise of the bad experts, sort of like I have a couple of examples where the expert used like a really out there methodology, and we were like, okay, this methodology is wrong 6 ways to Sunday, but court, even accepting this totally out there methodology, if we just fix these two or three things, so like one of them, for example, in one of my cases was that they had not calculated damages as of the date of the breach, which, like, New York law is unclear about many things, but it is abundantly clear that in New York you have to calculate damages as of the date of the breach, right? You can't, that's just a rule. So we were like, fix that one thing and then fix this other thing, and they didn't apply a discount rate, again, something that was like really fundamental, and you get a number that's exponentially smaller than the damages that this expert, I was on the defense side in this case, that the plaintiff's expert are claiming. And so, we ended up resolving the case on very favorable terms. But I think that was a good example of a case where we could have attacked this damages methodology 100 different ways. But I think it was effective to show, like, even if we live in this crazy alternate universe with this out there methodology, if you just fix these things that judge, like, really no one can argue about under New York law, you will see that this has to be wrong, or at least the numbers that they want are just like really out there. So I think that can be an effective way, because courts don't want to fight about 100 things. They want to pick the easiest, the path of least resistance to resolving disputes. And so if you can make it easy for them to say yes, I think that's better than trying to show all 900 ways something is wrong. I think this is a great question. I think the other effective way to respond to the bad experts' opinions are to try to, again, remember that the court may be bringing like a fifth grader's understanding of your expertise to the case. I mean, this is a challenge that I, as sort of a generalist litigator, I relish. I love working with really smart people like you all and taking your expert opinions and translating them into something that a court is going to understand. But I think this is often where the back and forth between experts and attorneys can be most successful. Is often I get like, these are the 13 to 15 reasons why the other side is wrong. Like, no court is going to have either the patience or the time to really dig into these things. So, like, can we bucket these into 3 buckets of things that are wrong, and can we start from that perspective and then dig into 2 or 3 within each of those buckets? I think the more you can simplify and take it up a level of generality while still being accurate. Obviously, you still have to be accurate and you still have to give the court the detail. But I think trying to find ways to make it, understood by someone with a fifth grader's understanding of your expertise can be very effective, rather than just going for like every bullet you can throw at the other side.